by the authority cited in support of the criminal objections. Because the same were decided by prayer. My Lord and Father, to the same. My Lord, that without prejudice, my Lord, to the foregoing. Without prejudice, my Lord, to the foregoing. Our colleague is applying the principles in authority cited. Because in all those cases, for example, even Chintu Brandon versus Warium, that is election petitioner bill number 64 of 2016, which I happened to argue on appeal, resulting into the decision cited. The question of recanting witnesses in all those authorities were not handled as preliminary issues. They were resolved in the final determination of the petitions when court had had the opportunity to scrutinize the various forms and versions of the affidavits, and court throughout all the authorities, both the High Court and the Court of Appeal, were following the precedent of gweyalopa, which was sterilist. And my Lord, I will submit that the prayer by the Petitioners' Council to expunge the three affidavits in question, that is of Ben Italian Casa, of Maumbe George William, and of Chem Malifan Mwanguzi, before the same are even admitted into evidence, and court has had the opportunity to listen to them, will be leading this report into a violation of the respondent and the three witnesses' constitutional right to a fair hearing under Article 28 of the Constitution of Uganda. Because what the petitioner is inviting this court to do is to condemn them minus hearing them. Because the decisions of court are that you must listen to them. Before a decision is taken as to what circumstances, under what circumstances was there a recantation, if any. Because, my Lord, as we are going to demonstrate a few minutes from now, the three affidavits that the petitioner challenges are not all necessarily recanted. Your Honor, for example, we will look at the affidavit of Ben Italian on court record, which is the first affidavit that the petitioner raised to have this court inspired. I thought Ben Italian Mukasa is not a petitioner's witness. Ben Italian Mukasa is not a petitioner's witness.
So I understand for Ben Italian, but what about for Yemba Hassan
My Lord,
and Maumbe George William?
my Lord, I'm coming there. Most of that. So Benitali is not a petitioner's witness. Neither is Benitali bound by section 19. That's rule 19 of the Advocates Professional Conduct Regulations that Council for the Petitioner had cited. My Lord, as I come to the second and third affidavits, I would like to say that this court is equally faced with another person. And that is balancing. That is balancing the obligation of an advocate under Rule 19, which was cited. That rule prohibits inducement, it prohibits tampering, it prohibits coercion, bribery, among others, of a witness by an advocate. My Lord, the court is tasked with the duty and the task of balancing between that rule and my Lord, Rule 17 of the Advocates Professional Conduct Regulations. My Lord, Rule 17, I will quote it verbatim, places an obligation, it imposes a cardinal duty on each advocate conducting a case or a matter not to allow a court to be misled by remaining silent about a matter within his or her knowledge, which a reasonable person would realize, if made known to the court, would affect its proceedings, decision, or judgment. My Lord, I would like to submit, in concurrence with my colleagues, that the allegations raised by counsel for the petition are unsubstantiated as against the advocates, for instance, of the respondent. They are unsubstantiated, there is no proof, and in all the authorities that were cited, the NALUKOOLA, the Judicial Brandon, in those cases, it is the deponents of the two versions of the affidavits who had to come to court. And the guidance of the Supreme Court is that they must be cross-examined. In all those cases, some of which I happen to be part of, it's the witnesses that pointed out to the court that no, it is the other lawyer, it is the other person.
What about these two, the two, Hassan and George?
Most obliged, my Lord. Most obliged, my Lord. And those two, my Lord, my what of Rule 17 was introducing me to the two. For example, my Lord, Maumbe George. Maumbe George William, my Lord. Maumbe George William, my Lord, is a very interesting. He's a very interesting my Lord, Maumbe George William has deponed an affidavit. And my Lord is saying, I've never deponed any affidavit. My Lord, I can't answer that question because I wasn't there. I'm not Maumbe. My Lord, there is. Yeah, there is. However, as to whether he swore it or not is for Maumbe to come before court. And that's what all those decisions cited. My Lord, the one in the petition or the one? By one. What's the plan? What's the plan? Yes, my lord, that's for the petition.
And what about the first respondent? Here among the witnesses as well.
Yes, my lord.
So now let's go.
Yes, my lord.
Yes, my lord. Now let's go. You have one for the petition, and you have one for the first respondent.
Yes, my lord. My lord, I would like first of all submit that the concept of recanting witnesses, as it is coined under our jurisprudence, is not expressly provided for under the laws of Uganda, like the word recanting witnesses. The akin to recanting witnesses is under section 153 and 154 of the Evidence Act, and those are the hostile witnesses. And how are they treated? My lord, I will come there. But let me exactly go to Maumbe. My lord, Maumbe is a very interesting witness. And Maumbe is one of the reasons why the Supreme Court has guided that when court is faced with these scenarios, because they happen for so many reasons, before you even inquire to apply section 154(2), whether it is the opposite party that has bribed, coerced, induced, or done what, court must ask itself, was even the first affidavit, if any, acquired under any better terms? And that is the duty that the Supreme Court places. My lord of page 22. It's highlighted.
So what does it say?
I read paragraph 4. This affidavit, if believed, says a lot about the way some witnesses are made sign affidavits during election petitions. It contains very serious allegations about the tenant, and one would have expected the deponent to be subjected to rigorous cross-examination. He was not. Now, before court can be able to say which of this, because for example, Judge Williams, my lord.
So in this decision of the Supreme Court, was this also a case where the witness was both sides?
Most of like, yes, my lord. In fact, it's Prematurity. But for Mount Pedro, it's more interesting, my lord. And it would be very interesting to have the same person before court. Because it says, I never deponed an affidavit for the petitioner. I never at all met the petitioner. I never talked to the petitioner. Even on the voting date, I did not vote because I was not in the constituency. But this is a witness that has been presented by the petitioner. And my lord, how does Maumbe come? Maumbe comes through another witness, not through the lawyers. Because in Tale, Mukasa is said to have bribed Maumbe. When in Tale is beginning his affidavit, he's a leader, he looks for Maumbe, says, Maumbe, did I bribe you? Because they said I bribed you. Maumbe said, which evidence? How come when I didn't vote? I was not even in Kawempe. And no, I'm willing to go to court and tell the court that I didn't vote and I've never spoken anything. My lord, those are the circumstances under which Maumbe comes. Now, the justice of the case is, should the court be requested to look out such a person in an election petition, which is an inquiry.
Okay, the submissions of the council for the petition not to lock out the witness, but subjective.
My Lord, the prayer was to
strike out the second, and after that, it was the first one, then he decided it was exactly.
My Lord, my Lord, from what we had captured, first of all, the right to cross-examine is available to all parties. And
the prayer was to strike out the second set.
Yes, my Lord, and those are the affidavits we are talking about. And the law is that they are not struck out preliminary at this stage. And my Lord, I will now go to the last one before I address specifically that issue, because the PO is premature. And we are going to submit to court why it is premature. But I would like to go to the last one, who is Chamber Nathan. So my Lord, on the first two, Ntale Mukasa is not the witness, not subject to the PO. The second one didn't even swear. He's saying I'm not recanting because I've never sworn. That one cannot also be called a recanting until court decides to him. The third, who is Nathan Moambuzi Chamber. My Lord, this one is the one that falls under what we call recanting witnesses. Recanting witnesses. And recanting witnesses are not illegal. I want to submit on that. Recanting witnesses are not illegal witnesses. My Lord, in highlighting that, I would like to say that courts have held that in election petitions, like what we are doing with right now, court is required to subject each allegation raised to a thorough and high level of scrutiny, and to be alive to the fact that in an election petition in which the prize is political power, witnesses who are inviolably partisan might resort to telling lies in their evidence in order to secure judicial victory for their preferred candidate. My Lord, that's what we are faced with in election petitions. It is an extension of the campaign. The campaign not ended, there was a declaration, and a new campaign has begun in court, where witnesses come with preconceived. So the jurisprudence of the country is that courts must examine each allegation. We are not arrogating sainthood on the respondent, and neither are the petitioners. My Lord, your brother, Honorable Justice Issa Serokuma, in Kamwine Dafi versus Musime Francis and 3 others, Kamwine Dafi versus my last High Court was suit number 96 of 2021. In citing the celebrated case of Musango Nambi Manufacturing Company Limited versus West End Distributors, 1969 1 the court held, I will quote verbatim, for purposes of demonstrating to court that the criminal objection before court is not a criminal objection. It's premature. So far as I am aware, my Lord, that's page 6. Page 6 of the Kamwine Authority. And the second last paragraph is where I am. The court here noted that the question to be considered here is whether the preliminary objection raised is competent to be dealt with as such. The main principle governing criminal objection was considered way back in the case of Musango, where court held that so far as I am aware, a criminal objection consists of a point of law which has been pleaded or which arises by clear implication out of pleadings, and of which, if argued as the preempt point, may dispose of the suit. A criminal objection is the nature of a demurrer. It raises a pure point of law which is argued on the presumption that all the facts pleaded by the other side are correct. And my lord, my emphasis is on this last part. It cannot be raised if any fact has to be ascertained. My lord, before us, court has no evidence, has no proof of any tampering, any bribery, any coercion, any inducement of any of the witnesses. So that is a fact that must be ascertained by one person like me, a lawyer, standing and giving evidence from the bar when I'm not a witness, cannot amount to proof before court, because these are very serious allegations that border on professional misconduct. So this authority, which has been consistently cited and is still binding, says it cannot be a PO if there are facts that have to be further ascertained through eliciting of evidence, or if what is sought is in the exercise of judicial discretion. Now, what counsel for the petitioner wants court to do is exercise discretion between these two sets. Which one? My lord, that ceases to be a PO. And we are submitting, my lord, that the PO is not a PO and should be overruled and dismissed because the court be pleased. My lord, the law provides remedies in these instances, and the remedies is what has been applied consistently, even in the authorities that is cited. As to whether the recanting is real or not becomes an issue for determination. And then evidence is left. And when court is finally determined, guided by the nature of evidence before it, it takes a decision, judicial. Now with us, I conclude by submitting that this court be invited, to follow the binding decisions of the Supreme Court, which are stare decisis, in answering the question before it. In answering the question before it. And for brevity, my lord, you sit on the bench, Justice Farida Ukiwa, in Uganda versus Segonga Musa. In Uganda versus Segonga Musa, in which he cited the Supreme Court decision of Okwanga Anthony, in which he cited the Supreme Court decision of Okwanga Anthony versus Uganda, Supreme Court, Criminal Appeal number 20 of 2000. In answering the question as to whether the evidence of a hostile witness. My lord, these are hostile witnesses in law. One who does this and tries to change a position are hostile witnesses. And hostile witnesses appear every day when you are in court. You cross-examine the fellow and he runs from his area position and changes and say, I'm now ready to say the truth. That is not illegal. It is in fact kudos to lawyers and court for doing the right work to make justice out of whatever situation is before you. Court says here, court is the Supreme Court. My lord, it is on that authority that we shared with court. It's highlighted. And it was held that it is a settled legal position that the evidence.
Where are you reading from?
My lord, page 3. On the Sion of Segonga. The expression hostile witness does not find what the quote there was quoting. It is going to mean testimony of a witness standing to depose in favor of the opposite party. We must bear it in mind that the witness may depose in favor of a party in whose favor it is meant to be giving through his examination, while later on change his view in favor of the opposite side. Similarly, there will be cases where a witness does not support the case of the party, starting from the examination itself. This classification has to be borne in mind by the court. With respect to the first category, the court is not denuded of its power to make an appropriate assessment of the evidence. Such evidence would become complete after the cross-examination. So once evidence is completed, the same testimony as a whole is meant for the court to assess and appreciate what fact. Therefore, not only the specific part in which a witness has turned hostile, but the circumstances under which it happened can also be considered. I don't just quoting also that the reason why the precedents have encouraged when those occurrences arise to subject the parties to cross-examination is for court to appreciate the circumstances under which the instances do arise. My Lord, with that, we would like to pray that court is to overrule the objection because it is premature and the law provides for remedies on how to deal with the same situation.
Okay, before you sit, what about the recent court of appeal decision from the 24th? I think Attorney Moses was the vice president. To address me on that.
My Lord,
it's the honorable 2025 last year.
My Lord,
It's the recent decision.
yes, my Lord. And my Lord, we want first of all to associate counsels for the respondent with the same decision and invite courts to follow the same decision.
What does it?
My Lord, we will go to page 'in the same decision, court was of the view that a decision on how to treat the same can only be arrived at after evaluation.
What the judge said. I think what the judge said more than
So let me get the court of appeal decision on that. And not printed here, but the frowning at the practice of lawyers was arrived at after a judicial inquiry, after cross-examination. You cannot at a preliminary stage say, for example, a lawyer influenced. A lawyer did this. In fact, in all authorities, even in ATAN itself, the witnesses are subjected to that process. And my Lord, just like I had highlighted, there is Supreme Court guidance on that, how we deal with them.
How a trial is supposed to be some specific negative.
My Lord, just a moment. My Lord, I would seek guidance on any specific page that you will be directing me to.
My Lord, it's page 17 for page 17 and 18. Paragraph 8, 9, and 6.
Yes, my Lord. So, page 17 is there are two possible approaches to dealing with affidavits of witnesses that switch sides and or recant their earlier affidavits. Firstly, it is wrong and unprofessional for an opposite party to approach the witness of the other party seeking to turn the person into a witness for his side. And my Lord, that is a statement of fact. My Lord, I'm saying it is wrong, but I'm also saying here, I'm interpreting this, that this is a statement of fact, because evidence had been led to that, even in the law court, by witnesses. And in this instance, my Lord, we are not going to treat counsel submissions from the bar as the evidence.
Did you read a bit about how the trial court should?
My Lord, once my Lord, first is wrong, then once that party is aware that person is a witness for the other party, the only option available to him or her is to meet in court and subject such witness to cross-examination. My Lord, this is a decision here. Although I'm saying that there is a Supreme Court decision and we have a principle of stare decisis, and I've quoted that authority and given it to court. But in the wisdom here, there are options that are available. And that is Bakaluba Mpasa Peter, which is Supreme Court, on how to treat. And my Lord, it was page 22 that I earlier highlighted, support. Yes, my Lord. The deponent has to be subjected to rigorous examination. Even before you reach the decision and the advice that the Court of Appeal is giving by Justice Godantende, you must have subjected this deponent. And by the time you arrive at the finding, whether there has been unprofessional conduct or what, is after a due process. And that's what the Supreme Court authority says. And my Lord, the Supreme Court was speaking from the case of Nelson. Nelson versus the Attorney General and another, it's 1999, East Africa. My Lord, it was unnumbered, but there is page 3. Where court Supreme Court says evidence by defectors must be received with caution and should only be admitted in special circumstances. So it doesn't say that evidence by defectors acts like a Russian poison. Don't touch, don't see. No. It must be received by caution. And if it is to be admitted or relied upon, the Supreme Court stealing of Kwanga Anthony, which I've cited, guides how court. Because between the two sides coming before court, we don't know who is right. It is for court to determine who is right. So before you are no angels, my Lord. I beg so.
Also the decision of ISA. But for the record, you have it. Not on the issue of the nature of the people, my colleague looked into the decision of the Supreme Court decision of the ISA district and branch. We have supplied the copy of our only. This is the copy of court. But not the issue of recanting evidence, which my Lord, in our view, has been settled by the Supreme Court. The decision of Nelson that has been quoted by my colleague, Nelson University Archbishop, it's a decision of the Court of Appeal in Kenya, Tanzania, sorry, which was also determining a similar situation. And my Lord, there had been several recanting witnesses. My Lord, in determining that issue, court was faced with two scenarios. One is, do you expunge from the record such evidence for the recanting witness? And two, what then do you do with it? My Lord, in deciding that decision, the court quoted the decision of the Supreme Court of India, that is Khan versus Ahmed, 1975. So my Lord, is supposed to show that the phenomenon of recanting witnesses in election processes is not new. In 1975, the Supreme Court of India also decided the same decision, and the whole thing in the Supreme Court of India was that if you have such effective witnesses, one, allow their evidence to be recorded, but in assessing, which is the role of courts, you now have to weigh under what circumstances did they make the first evidence, and what are the extraneous circumstances did they recant the evidence that had already been on record. And my Lord, that is the holding that the defector's evidence cannot be rejected, but it must be received, and the court has to deal with it with caution. With caution, my Lord. My Lord, the respondent, the petitioner also had alluded to the decision of Mbaju. That I think is the decision of Justice Seconda and Ten. And my Lord, when you look at the reasoning, it all stems from Nelson, and then Bakaluba Kitamkasa, and then it has to flow like that. So it had already been determined that how do you then deal with it. My Lord, in Bakaluba Mkasa, Peter, the court said that the only reason why you would close out an affidavit that has been recanted is one, if it has not been deposed before a commissioner of course. So that would then be a preliminary point of law, that in as far as the law of affidavit is concerned, this affidavit does not squarely fall within what would be acceptable by court. That is one. My Lord, in as far as we understand the PO of the petitioner, that is not the case. The case is that the affidavit was properly sworn. Our only problem is that it is recanted. And the Supreme Court has guided that in cases where you're faced with such a situation, that witness must be brought and put to stand and rigorously cross-examined. My Lord, among the other decisions that were was the decision overturned here, which you had referred to. My Lord, the judge also should be page 20, but my Lord, you already have it. The judge, in all determining all this decision, Chintu, Brando, Nabukeira, said that the role of determining whether or not, or what weight to give to the evidence of a recanting witness is report. And that, my Lord, implies that you first have to allow the evidence of report, and then when you retire to determine this matter, assess which of the stories do I go with, and under what circumstances do I say this has more weight and this does not, my Lord.
That very decision was paragraph 59.
Paragraph?
That 59, the attorney was
Well, I don't know whether the one I have is numbered. It's not, my Lord, the one separated is not. Because I think, my Lord, you were talking about embargo. Yes, but my Lord, what in other words, my colleague, in conclusion, I would say it is not a question of either or.
59.
That 59, the land trial judge ought to have struck out the second set of the 12 affidavits sworn by the persons who had already sworn affidavits in support of the petition. The persons were approached by the respondents, counsel, and made to swear affidavits recanting their earlier sworn affidavits in favor of the petition. The respondent was barred by law from approaching and talking to this matter. I don't know. But my Lord, this paragraph, if I may, this paragraph has very unique approaches. One, it alludes to that the respondent stands to approach. Approach is born of evidence. You must first prove that the lawyer approached the witness, either coerced, coalesced, or forced or induced them to give you evidence. My Lord, that is missing in this case. That is missing in this case, unless my Lord would be receiving evidence from the back. My Lord, that is one. But all the elements in this paragraph, my Lord, are that these things must be born of evidence. And the evidence has to be either by a witness himself saying that, for instance, Alex Uganda approached me, promised to buy me something, and then that is how I gave evidence. But my Lord, the point we are making really is that this is a court of appeal decision. And our arguments are on the basis of the Supreme Court, which says that one, call that witness, cross-examine them, and find out what are the extraneous circumstances under which they are recanting their evidence. Because my Lord, in an inquiry of this nature, I think that would be pertinent. My Lord, lastly, which is what I really alluded to in the case of Nelson, which I have supplied the court. When my Lord, you retire to read that case and the quotation or excerpts from the decision of the Supreme Court of India, they have been called election turncoats. That is the point, that election turncoats. And my Lord, the background to that, in election processes, these things should not be treated as strange, because they will not stop in this petition, they will happen in petitions to come, but how do you deal with them? The Supreme Court, as early as of India, as early as 1975, had already determined that that witness has to be brought, and then court would be interested in understanding how did you shift from the earlier position to this position. Because my Lord, in the decision of Nelson, the recanting witness had actually been part of the party. It was called Mapena. That and was part involved in even in the electioneering activities. And then when they came to court, he recanted, and court was faced with the situation. How now do you deal, for example, with the Secretary General of NRM giving evidence to National Unity Platform? Court said, no, we are not aware of the circumstances under which that person changed their mind. So it is important that we call them, cross-examine them, and then after cross-examining, we shall be able to see how to treat this evidence. Because that, my lord, is the jurisprudence as we know it. Until the Supreme Court, my lord, determines and says, well, you have to take this approach. The approach is that you have to call those witnesses and they come to court, cross-examine so that court can make its informed and erudite decision as to whether and how they recount the evidence. Lord, I beg submit. My lord, also for the record, my lord, we have the first respondent in court, Mr. NALUKOOLA, reimbursed. I don't see the petition. Petition, I don't.
Yes, my Lord Samuel Mulindwa, Lord, I raise the point that we are using the premature. And probably that is why we are finding it difficult in taking home some of the points we are raising. My Lord, we are proceeding under the presumption that we are this has been admitted. My Lord, the practice that we've been in, at least through 15, and if you look at all these decisions, my Lord, we used to actually, when affidavits are before you, my Lord, they will first be deemed read before we can proceed. My Lord, in the current situation, why I believe they are premature may lead to a miscarriage of justice is you realize even the directions to this court on how a hearing has been conducted. There is even space for the petitioner to withdraw the evidence of a witness who is saying, I never saw any affidavit. My Lord, if you looked at the directions for hearing under Rule 9, nine of the rules, under the Parliamentary Elections Act, my Lord, you realize that the process we are miscarrying the process because upon presentation of the petition, serving the petition, the judge, with consent of the parties under sub-regulation 2, will hear the parties on whether any of the parties can, that is sub-regulation 2, paragraph A. You may receive written notice of an intention not to oppose. You may receive written notice that the petitioner wishes to withdraw the petition. My Lord, you may record any facts which have been agreed by the parties. It's a process. After recording the facts, my Lord, you may settle the remaining issues, if any. My Lord, after that process, you give directions as to further and better particulars, which may be necessary to avoid surprise appearance. Most important, my Lord, you may give directions as to the evidence to be called at trial, and whether witnesses should testify by affidavit evidence as the examination of the chief of a witness with oral cross-examination and re-examination, or by documentary proof, and whether the case will be had a party of judgment. My Lord, we have jumped. Before we've done all this, before even pleadings are closed, most important, before pleadings are closed, we are now jumping into even discussing matters. There's a study. We are even in the beds. My Lord, the spirit of the decision of Muksa that has been cited, you will find in the ratio somewhere, even if you raise the people, my Lord, on page 6 of the decision which cited, that is you will find that court say that it raises a pure point of law which is argued on the assumption, my Lord, that all facts pleaded by the parties either side are correct. My Lord, we still have facts coming in court. I deem it that affidavits are part of pleadings. My Lord, it will cause a miscarriage if at this stage we went into detail and when I strike out these affidavits. My Lord, we stand also, we stand the danger. If the ruling on these POs is to come at later stage, my Lord, probably we had more recanting witnesses. Yes, probably we had more. So it would be difficult on whether to bring in other people who are saying after that, we did not. So I believe my point, the point, my Lord, is we are dealing with too much, and this is an inquiry that is submitted. My Lord, in the case of Honorable Mama Babas, the Supreme Court determined that petitions of the nature are an inquiry. At this stage, you can't start closing out any evidence before you even inquire. We've not started trying. Before an inquiry, we are jumping. You know, that was in Mama Babazi versus your Computer Museveni and others where we participated with our senior colleague. We took there's a lot of literature discussing on whether that's election petition number 1 of 2016, on the nature of an election petition. And the finding was, it was an inquiry. An inquiry is an investigation. In an investigation, you don't simply close out any information. And that's what supports the lengthy submission of my colleagues. I submit that you find, my Lord, that fair criminal point of law is premature. It should be overlooked. It may cause a miscarriage of justice and a misdrive of this matter. And we are I'm obliged.
My Lord, I correct that they could put the points of law.
Yes, my Lord, of course, I do the very interesting arguments of they are written by misconceptions and misunderstanding of what a preliminary objection was about. Let me start with, my Lord, the decision of Nambo's. Now, my Lord, I have read that, and while my colleagues were submitting here, I got the feeling that we're reading from a different script. That decision, my Lord, is inapplicable. The current circumstance. Why? Number one, the Supreme Court did not. Now that's why you kept asking, did not specifically deal with the issue of recanting witnesses. It's not there. And then that will be predicted in the matter. And it did not make a decision on the issue of recanting witnesses. They are quoting the decision by implication. Secondly, my lord, that decision did not consider anywhere Rule 19, the advocates professional conduct regulations. It's not there. Let's again, they have a difference. Thirdly, my lord, even if that decision had taken into account those two principles, the current decisions of the Court of Appeal would be the correct position of the law, and I'll tell you why. The current decisions of the Court of Appeal would be the correct positions of the law. The decisions as late as that time. Why, my lord? Because of the doctrine of concurrent or ordinate jurisdiction. My lord, under Section 85(3) of the Parliamentary Elections Act, the Court of Appeal is the final court of appeal in parliamentary elections. It will be, my lord, that decisions of the Supreme Court previously was the final court of appeal, and those of the Court of Appeal now, as the final court of appeal, rank at the same level, under the doctrine of ordinate jurisdiction. My lord, for that principle, I rely on the decision of Young versus Bristol Airplane, Young versus Bristol Airplane Company, and Team 44.1K. That issue, my lord, what I'm quoting has been quoted in several Supreme Court decisions. That's something to remember. Fourthly, my lord, that is why that decision that I've just quoted of Mangos was referred to in Alex Brandon on this exact subject, and the Court of Appeal a different answer. I'm sure Mr. Alex Brandon was, since he says he had this. They considered that issue, my lord, at page 11 up to page 12 of that decision. They looked at it, they found it applicable in the terms proposed. Question number 2. Is this a default? Is this premature? Is this a premature? My lord, it is not. And my friend's submissions on that point, I think, are because of the misunderstanding of what the people is. This people is simply that there are two affidavits on record. There is one in support of the petitioner and another in support of the first respondent. That is a fact that needs no further evidence. Point number 1. Point number 2, that the lawyers, my colleagues for the first respondent, have assisted these witnesses in preparing, understanding, explaining, translating, and these affidavits, filing these affidavits of court record is not in dispute. Because they said so in the affidavits, my lord. They said, I have been helped by the lawyers. I have been helped by the lawyers. Those paragraphs are there, my lord. And you see them in the affairs of Maumbe, Kasa, and Jem. That fact, my lord, is not in dispute and needs no further proof. And that is the nature of my people only. I am saying you cannot have two affidavits on record. As simple as that. And those two facts need no further proof. Corollary to that, my lord, I think I should also say this in passing. Submissions of Mr. Minister. My lord, pleadings are closed. I'll give you the student say, pleadings are closed. Somebody you add this decision, but you're forward. Kind of reason before. Versus within the purpose. Those pleadings are closed when the answers are filed. This is the issue of the Court of Appeal. Now, but when they talk about the facts in Musa this week, I have just told you the facts that constitute my PO. My facts are only two. One, that affidavits are two affidavits from the same people appear on the record. That's the fact I am trying to. They went into so many other things, but this is my fact. They went through every relevant things. The second fact is that these affidavits were prepared, filed, translated, explained by my colleagues. That one needs no further proof. My lord, these two facts I'm talking about were prohibited in all of the authorities I cited. Whether it's Chief, whether it is Mbaju, whether it is Akan, whether it is NALUKOOLA, the Court of Appeal is simply saying, don't touch. Don't bring second affidavits. Now, my lord, at that point, they then came into what I'm submitting. They are saying, you can cross-examine. You can cross-examine. It is okay. That's what I am saying. That the approach is not for you. When you hear all of these things they have been saying, did I bribe? Did I induce? Did I do what? It is okay. Those things do not come to the record by way of a second affidavit. No. What the courts have told you, you wait for cross-examination, which they have extensively alluded to, and then you bring out all of those facts. Okay, you do not bring them by way of a second affidavit. And my lord, on the question of hostile witnesses, witnesses don't become hostile in lawyers' chambers. That's section 153 that my colleague referred to. A witness becomes hostile when he has been asked a question and is answering contrary to the witness, the part that brought them. You will not sit in your chambers in Mengo and say this witness is hostile. I must take you to report. No. They don't become hostile in chambers, in lawyers' chambers. They become hostile here in the dock during examination, which is what I'm telling you, which is what the Court of Appeal has said. That is the approach. Take out the second set of affidavits, let the witnesses come to court, and they undergo all manner of tests through cross-examination by the court and by the other party. So all the things they went into, there is no proof of bribery, inducement, all those ones are not my PO. All of those facts they will hear during cross-examination. My question is, you have two affidavits on file. The Court of Appeal has said the second set must go. Then what do? You do what they are saying. Cross-examine extensively, test veracity and reliability in cross-examination, not by filing a second affidavit to the motion. But Mr. Uganda alluded to the fact that Maumbe said it was Maumbe, says he never signed an affidavit. All that comes in cross-examination. Okay? It's when you find out, did you sign an affidavit? Says no. Did they approach you? No. You don't make them swear a second affidavit. You establish all of those claims during cross-examination. My lord, in one of the students I gave you earlier, that's what the Court of Appeal says. I'll take you there from my lord by day. This is my Lord Bonama that you have already there. My dear Lawrence Bonama Obo. I know that page 13, paragraph 29. This is what the Court of Appeal says. Therefore, if he believed the deponent had indeed been coerced into deponing an affidavit against him, the course of action that was available to the first respondent, just like Mr. Nambi, was to subject Mr. Wahale to cross-examination to establish the veracity of his claims. The approach is not to file a second affidavit. You do as they are acceding. You cross-examine. You don't file a second affidavit. My PO is that you have 2 affidavits on record, and the court of appeal has said no. Take out the second set, then deal with the rest of the issue. I can give you situations and questions. Now, my lord, the issue of witnesses are free to become hostile. They are free to recant. This recanting has been there for ages. First of all, yes, it has been there for ages, but the court of appeal has told you it's illegal in Uganda. Clear. In all of the decisions I have cited, the court of appeal has told you it's illegal in this country. It doesn't matter whether it's been there for ages in India, Tanzania. This court, this country has told you recanting is illegal. In no uncertain terms, and that the other party is barred by law from approaching the witnesses of the other side. In no uncertain terms, the court of appeal has told you. Now, whereas, my lord, witnesses may change testimony. For example, in cross-examination, I bring a witness and he says weird things. Whereas counsel cannot control what the witness says in the box, there is something a lawyer can control, my lord, which is the central point in this matter. Where a witness says, I want to say something else, I want to recant, that is right. But there is something a lawyer must do. These colleagues of mine also have known. When clients came to them and told them to want to recant, they ought to know the law. They would have told them, wait, during cross-examination, sirs, we shall handle that matter here. Okay? That is what Chief Alex Prematurity says that Mr. Uganda argued. He says that they ought to have known and told the witnesses that, please, yes, we have heard you did swear, you were taken to court and everything else, but wait, during cross-examination, we shall handle. Because my colleagues know the law that the court of appeal has told you, don't file a second affidavit, wait for that witness during cross-examination and ask all manner of questions. That the lawyer has no right to. In fact, it is an obligation to tell the client, please, let's not take this affidavit here. For that, my lord, I rely on this union. That kind of lawyer, that is union, Myers versus Stedman. House of Lords, same situation. What did the House of Lords say, my lord? Because last time someone was saying, what if they existed? What if they existed? The House of Lords said, the solicitor, I'm reading over to you. The solicitor cannot allow a client to make whatever affidavits he thinks fit, nor can he escape responsibility for careful supervision and investigation. If the client will not give him the information he is entitled to, or he insists on swearing an affidavit which the solicitor knows to be perfect, like in this case under our law, what does he do? Then the House of Lords say the solicitor's proper course is to withdraw from the case. That's the same situation I've highlighted other areas that are clear in this point. So it doesn't even arise that as the lawyers, we are not the ones who approach. The law bars even Mr. NALUKOOLA. And I told you, my lord, last time that it's interesting. If you look at those affidavits, they were all translated by somebody from Mr. NALUKOOLA's law firm. And the court of appeal has told you, whether you are the respondent, whether you are the lawyer, you are bad. Don't touch the forbidden fruit. But just a bona and hold it in a hand. So, my lord, you cannot even obtain in this argument that Rule 19, we have not ruled the lawyers in use for that. No. The prohibition is against both the first respondent and the lawyer. The prohibition is against both the client and the lawyer. Now, on the issue of how do you approach this scenario, my colleagues have gone to great length, call them to tell you whether they are private. My lord, Atan has told you, okay, and I have argued that under the doctrine of concurrent or ordered jurisdiction, that they should be at the same level as in our position, even if you have said something else which it doesn't. Atan tells you, your lordship, that what you do when you are faced with this scenario, kindly strike out the second affidavits. None of the decisions, my lord, I have quoted to you of the court of appeal, including Atan, tells you that first listen to them. No. None of them says that. not single one of them says, first listen to them to see what they are saying, then strike out. No. If there is you, once you see to affidavits, strike out the second set. Then let the witnesses come to the box. Okay? Because my lord, it is not only through a second affidavit that this evidence my colleague is referring to is the only way it can be received by the court. No. It is not through a second affidavit that the evidence they are talking about can be received by the court. It can be received in viva voce through cross-examination. So, my lord, what the court is saying, the concept of a second affidavit doesn't appear anymore. And it's not the only way that all manner of evidence they are talking about to prove whatever they want to come to the court. It can come to the court and it will, and the court of appeal has told it will come to cross-examination. Not any other way. The affidavit of Musango, I think my colleagues misunderstood my objection on that point. I did not say Mukasa recanted. I only said that Mukasa procured the commission of the illegality we are dealing with. There are two persons who recanted, Jemba and Nathan. Jemba James Mwanguzi and Nathan. For Mukasa Antari, my argument was that if the court is convinced that this was an illegality, he clearly, and the deponents clearly say he is the one who brought them into the illegality. I am saying, Papa says you have participated in that illegality. It was out of state. And I've introduced that illegality to you, and my work cannot see what it is. My lord, my colleagues have also referred to a couple of decisions of the High Court. That's surprising me. I don't want to. My lord, I don't want to let my colleagues understand the level of this case. But when we are here discussing court of appeal decisions, I think there's no kind of response. Now, my lord, in Kawanga Semo, let me just go that way. In Kawanga Semo, even if this court had an opinion different from Atan, different from Brendan, different from Nambi, it cannot take it. In Semo, the Court of Appeal disregarded two decisions of the Supreme Court on the same matter. The lordships in the Supreme Court say the Court of Appeal was not entitled that if they need to have different opinions. So these decisions of the High Court, those ones are out of state. Even if my lord heard a different view, when Alex says do this, that is, when Atan says do this, that is, even if you want a different opinion. And that matter, that I just referred to also, was captured in Young the third point. So my lord, you have taken decisions of the Court of Appeal that are binding on the court on how to approach this matter. And I've distinguished and I've taken away the decision of numbers, and even if it were there, it would be accepted. So really, we should not be entertaining decisions of the High Court. I'll give you the decision of the High Court. Now this issue, we shall handle the people later. We shall handle the people later. Why? Points of law, my lord, are taken at the earliest. I've taken at the earliest. My lord, there's a decision here. I don't know if I have it in my file here. In election petition, immediately. I'll refer to it, my lord. I write in my head. It is Serapi, 1997. It says when in an election petition a people arises, you immediately review it. To avoid extending that decision, confusing issues. So let us not confuse issues that my colleagues are saying here. We must hear who bribed them, whether they were coerced. The second act that is here, take it out. All those other things we shall hear. Council referred to Rule 17 of the Advocates Professional Conduct Regulations. Rule 17 does not allow you to file a second affidavit. Does not allow you to file a second affidavit. It tells you, yes, you tell court what happened. Mr. Oganda, you tell court that Maumbe was bribed or coerced. That's fine. In cross examination, not by go filing a second affidavit. You still have the duty, even in cross examination, to tell court what happened. Okay? But you do not file a second affidavit. That rule does not permit him to do so. Mr. Rugani again said that recanting is not being discouraged. It is not. The court of appeal told you it is not, and I will deal with. With those submissions, my Lord, I pray, I reiterate my prayer that the second affidavits of whichever they can want and my own will continue this part, second step. Then my Lord is subject to those who on the basis of their academics, support of prediction, a thorough scrutiny, a credibility test, a reliability test in accordance with the decisions. For the affidavit of Ben Mukasa, my prayer, my Lord, is that for him having procured a commission of the legal community, that this part out for that reason and the basis of my plan.
Before I proceed, I want the judge.
Yes, my Lord, we saw that the affidavit is the time was an inadvertent error. But my Lord, the authorities of the Court of Appeal and the Supreme Court, some of us in Master Cycles, Casalagora versus Casalagora Supreme Court, as is okay, say those are my details. Regardless of the date, some of us in Master Cycles and Casal. My Lord, I don't have them here, but I can cite them to you because I have it in my head. Some of us in Master Cycles, the Court of Appeal decision, and Casalagora versus it is a Castle Growers versus Supreme Court Justice. Okay, I can provide them with the other should say. I will
Delivered on Friday, 9th of May, at 9 a.m. Thereafter, the court shall conduct a public conference for the petition. Friday, 9th of May at 9. Okay. Olwaleero ensonga ezaateekebwayo bannamateeka oyo atidde okujja mu kkooti ate yawaaba omusango guno esobodde okuddamu ensonga zaabwe ez'okugamba nti abajulizi baffe abajja ne bawa obujulizi mu kkooti eno nti tebawangako Nambi bujulizi waleeta petitioni ye mu kkooti naye agamba bwe babagibwa rekodi tusobodde okuteekamu ensonga zaffe eziraga lwaki kkooti tesaana kukugirwa kutunulira ku bujulizi obwo. Ekisinga byonna Supreme Court yalagira dda nti zino ensonga z'ebyokulonda teziba zaffe, ziba z'Abannayuganda. Kyekyo lwaki ebeera inquiry kuba kunoonyereza. Kaakati Nambi kyali mugamba kkooti nti abajulizi abajja ne bagamba tebasayiningako ku mpapula za Nambi, ali mugamba abajulizi obujulizi bw'okwogera ekyo kkooti erina kukola ki kutunulamu. Ekisooka akireese ku budde obutali butuufu, kubanga ekirina kujja batandise kulinza musango. Katuyingidde ebintu ebibuzaabuza okuba nti nno tulinga abatandise okuwuliriza omusango bwetutanaba nakushedulinga, bwetutanaba nakusalawo kutambula kutya, bwetutanaba nakusalawo bujulizi ki obulimu n'obutalina kubaawo. Tulowooza nti ekyo si kituufu, naye obuyinza buli eri kkooti ku Lwokutaano okusalawo webegera kutambula bweti, naye gujja kuba gusoose kkooti yonna mu nsonga za kkooti mu musango gw'ebyobufuzi nga guno gwa election petition okutandika okuwuliriza omusango ate naba nakukola kye bayita scheduling conference. Tekulowooza nti kijja kuba kituufu, n'ekisinga okuba ekikulu tituli beeteefuteefu. Wabaagala bali babaleeteefu tubasoyesoye ebibuuzo ku budde bwabwe, naye ate tubuuzo naleeta ati omuntu agamba sibangako omujulizi wo, wabbo bagamba nti oyo omujulizi agamba nti si mujulizi waffe, wandimulinze ne tumala omuyita n'olyoka omusoyasoya ebibuuzo ebikakasa oba mutuufu oba nedda. Omuntu akugambye si mujulizi wo, tamanyi ofiisi yo gyeri, talayirangako kirayiro kikuleeta mu kkooti, kati onaaleeta muzimu gwe. Ndowooza ezo z'ensonga zetulinze ku Lwokutaano omulamuzi atubuulire oba batambula bulungi, oba abajulizi abo bagibweko kaakati, oba balinde basoyasoya ebibuuzo kati tayimu yakyo etuuse nga omusango gutandise okukola ki okuwulirizibwa. So basically difensi yaffe nti emisango gyonna gye tubaddemu gigamba nti abantu nga bwe batyo terina bagoba ku siteegi erina okubawuliriza. Kyekiri kyenjogedde nti kkooti ensukulumu yagamba musango gwa Mama Mbabazi nti eno ebeera inquiry kuba kunoonyereza, naye ate onaanoonyereza otya nga abajulizi abaleeta obujulizi obagobye. Tugamba nti kkooti terina buyinza okuba mujulizi yenna ajja mu maaso gaayo okwogera ku nsonga z'ekawema, erina buyinza bwawuliriza. Today we made our response and reply. The preliminary point of law objection by the petitioner, who is seeking an order of this court to strike out the affidavits of the respondent, specifically of those who deny being witnesses of the petition. We have witnesses who say, whereas we are aware that there are affidavits on record which were not sworn by us, we do not know the lawyers who prepared this petition, except for knowing Nambi as a candidate in the election. We are not her witnesses in this matter. Now, Nambi and her lawyers are saying those witnesses who are denying us the evidence should not be given an opportunity to speak. Well, clothed with their decisions of the Supreme Court, they are telling this court that this is an inquiry. Actually, these witnesses cease being their witnesses because they cannot even withdraw this petition without leave of court. They only have leverage within the law to withdraw that evidence. I would beseech them, if a person came and saw an affidavit with this signature, which is actually relating to the signature of their ID, the right thing to do is to withdraw the evidence that has been denied by the But now we've gone into a trial, we are going into issues which you've had. Besides that witness having said they never signed, the affidavit is even not dated. Besides that, it is not commissioned. So it is no evidence at all. So what is saying, remove the evidence which has fully been signed, attested to, and leave evidence on record which is not dated, which the witness is saying, I never signed, I never swore to. We are waiting for the court. We may not go into the merits of what will happen. We are waiting to see if the court determines that such witnesses should not be heard. It would be against the cardinal rule of the right to fair hearing, where you deny evidence to come on record in such a matter, where you are duty bound to inquire or to investigate. You cannot carry out investigations when you are locking out potential witnesses, people who have evidence. So we are waiting for a ruling on the 9th, determining on how to proceed from here, but we are ready in any case. Whatever the decision, we are ready to defend the rights of the people of Kawempe who chose their MP, the Honorable Nambi.
And maybe fundamentally, if you have nothing to hide as a petitioner, then you should not fear witnesses coming to court. That's what we are saying. Oba tolina kyokweka kyonna kyonna ng'omutwe yawaaba omusango tolina kutya polisi enalina kujja mu kooti kola ki waba polisi era ffe kye tusaba kooti ekkirize buli omu azise nga alina kyayogera temuwulirize then ekola okusalawo kwayo.
Well, you have heard from my lawyers. What more should I say? Nambi filed a very frivolous petition, like I alluded the other time. Indeed, she's inviting court to handle a very minor issue, which will suffer. There is a rule, the minimis rule. Yes, courts are not concerned about such minor issues. Now her lawyers are bringing out minute other issues to waste our precious time. And indeed they want to build on that, to show the world that they have something serious here. But there is nothing. It's an empty petition, brothers and sisters. It is meant to waste our time. It is meant to make the people of Kawempe North constituency suffer. I would be now representing them effectively, but we are here defending incompetent petition filed by Nambi. I don't know why. But sebo ne banyabo bannayuganda abalungi abali. Mukyala Nambi yaleeta akantuntu akatali namakulu ng'akiyita petition. Ate kakati atuzza mu buntu obutono ennyo. Abajulizi akakabaka ke, abaperereza bamweganye mukazi wattu oba ye yalagawa, ate aganye n'okujja mu kooti awuze omusango gwe yawaaba. Yanjozaayoza nze gwe mulaba e Kawempe North eWambogo, n'agamba Nalukoola wampangudde, n'atuuka n'okuwa ensonga n'agamba naye wabadde tojja kumpangula lwakuba abajja ati baakukuba. Ne neewuunya lwaki teyagamba bakadde be kumusindikira kujja ati mukubamu. Alemesezza abantu b'e Kawempe North constituency okufuna obuweereza obulungi, okubakiikirira mu ngeri ennungi. Kuba kati entebe ngituddemu makiikakiika. Gw'ataafuna bululu, gwagenda awaaba emisango egitalina makulu egitasobola kuwangulwa. Balooyawo bali mu buntuntu bazannya wano jangu onkwekule. Bannange bano tubasobola bassebo ne bannyako. Saagala mubeereyo nga mweraliikirira bannakawempe North. Mukyala Nambi ebintu byalimu tebitegeerekeka. Bakulida bange bamaze okubagamba ensonga. N'omulamuzi aziwulidde. Nkakasa omulamuzi oyo ajja kutagandula ebintu, ajja kuwa ensalawo oyo abagambe bye mwogera bya butaliimu bali mu bya kandolindoli omusota gwa ttete wali oyagala gutemulaalo mbwendera ewunya amalu byali wunya eki mwebale nnyo mwebalire ddala Come on. Yesu mulungi atwala akaseera kano muzikirize mberekereze menga nkoma wano tujja kuba tuddamu olundi muzikirize mberekereze mukama abankomere tujja kuba tuddamu ku Friday era nja kuba mbawa buli kimu ekigenda mu maaso mukama abankobere zitadde ndikyambadde musomesa ku kamera kubanga nkuweereza omulungi abadde atwala kukulu Kiro TV bwebale nnyo genda wa sagambiddewo nti nabijjeewo